So, ano naman yung tinutukoy natin pag sinabi nating ownership is acquired by delivery? The meaning of the phrase, he shall acquire no real right over it until the same has been delivered to him, is that the creditor does not become the owner until the specific thing has been delivered to him. Hence, when there has been no delivery yet, the proper action of the creditor is not one for recovery of possession and ownership, but one for specific performance or rescission of the obligation. Since wala pang ang delivery, wala pang real right si buyer or si creditor doon sa property. So, personal right and real right distinguished. Ang kabaliktaran bale ng real right is personal right. If we would remember sa previous discussion natin, meron din tayong tinatawag na real obligation and personal obligation. Huwag kayong malilito dito sa personal and real obligations versus personal and real rights. Kasi pag sinabi nating rights, pwede siyang i-enforce. The person entitled has the right to enforce the same. So, personal right as a definition is the right or power of a person or creditor to demand from another, usually the debtor, as a definite passive subject, the fulfillment of the latter's obligation to give, to do, or not to do. Real right, the right or interest of a person over a specific thing, like ownership, possession, mortgage, lease record, without a definite passive subject against whom the right may be personally enforced. As to subject, there is a definite active subject and a definite passive subject. Meron daw definite active and definite passive. Ano nga pag sinabi natin definite active subject? Merong definite na creditor or obligee. Pag sinabi natin definite passive subject, meron tayong obligor or debtor. Pagdating naman sa real right, there is only one or only a definite active subject without any definite passive subject. Meron lang daw definite active pero walang definite passive. So, meron lang na active subject which pertains to the creditor or obligee. Pero walang definite passive. Walang definite obligor, definite debtor. As to binding force, personal right is binding or enforceable only against a particular person, while real right is directed against the whole world. Yun yung major na distinction nitong dalawang ito. Real right is directed against the whole world, while personal right is binding or enforceable only against a particular person. Example, X is the owner of a parcel of land under a Torrens title registered in his name in the Registry of Property. His ownership is a real right directed against everybody. There is no definite passive subject. If the land is claimed by Y, who takes possession, X has a personal right to recover from Y as a definite passive subject, the property. If the same land is mortgaged by X to Z, the mortgage, if duly registered, is binding against third persons. A purchaser buys the land subject to the mortgage, which is a real right. So, ayun. That was 1164. Now, we proceed with 1165. When what is to be delivered is a determinate thing, determinate daw, or specific, The creditor or obligee, in addition to the right granted to him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obligor delays or is promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. So, next is the remedies of creditor in real obligation. So, again, real obligation na yung tinutukoy natin, no more real right. Hindi na siya real right. Again, pag sinabi nating real obligation, obligation to give. Creditor, ito ay ating active subject or obligee. In a specific real obligation or obligation to deliver a determinate thing, the creditor may exercise the following remedies or rights in case the debtor fails to comply with his obligation. First, demand specific performance or fulfillment of the obligation with the right to indemnity for damages. Or demand rescission, kakanselahin na lang daw. Or cancellation of the obligation also with the right to recover damages. Palagi may right to recover damages. Or demand the payment of damages only where it is the only feasible remedy. Yun yung remedies ni creditor pagdating sa real obligation. In an obligation to deliver a determinate thing, the very thing itself must be delivered. So, clear tayo dyan. Pag determinate thing, the very thing agreed upon must be delivered. Consequently, only the debtor can comply with the obligation. This is the reason why the creditor is granted the right to compel the debtor to make the delivery. It should be made clear, however, that the law does not mean that the creditor can use force or violence upon the debtor. The creditor must bring the matter to court and the court will be the one to order the delivery. The rights to demand fulfillment and rescission with damages are alternative, not cumulative, meaning the election of one is a waiver of the right to resort to the other. In case of rescission, the parties must return or restore to each other what they have received. Ayan, clear tayo na alternative yung right to demand fulfillment and rescission with damages. Hindi pwedeng pinili ko yung isa and the same did not succeed, so yung sunod ang pipiliin ko. Hindi. Isa lang dapat. A generic real obligation, obligation to deliver a generic thing, on the other hand, can be performed by a third person since the object is expressed only according to its family or genus. It is not necessary for the creditor to compel the debtor to make the delivery, although he may ask for performance of the obligation. In any case, the creditor has a right to recover damages under 1170 in case of breach of the obligation. So, proceed tayo sa another scenario where debtor delays or has promised delivery to separate creditors. Generally, the happening of a fortuitous event. Sa madaling sabi, pag sinabi natin fortuitous event, it is an event which cannot be foreseen or that which, though foreseeable, pwede mo siyang ma-predict, is unavoidable. So, sabi dito, generally, the happening of a fortuitous event will exempt the debtor from responsibility. May exempt daw si debtor from responsibility. However, paragraph 3 gives two exceptions to the general rule. Paragraph 3 likewise refers to a determinate thing. An indeterminate thing cannot be the object of destruction by a fortuitous event because genus non comperit or genus never perishes. This is an important doctrine we should all know. Ito yung genus never perishes. Halimbawa, Ang object ng contract is a horse. And yung horse is sinakay sa barko and subsequently biglang bumagyo, dumubog si barko. Question: absolved na ba sa responsibility si debtor? Hindi pa, kasi yung napag-agrihan naman is an indeterminate thing or generic thing. And so, pwedeng magbigay ng replacement si obligor. Which, ang required lang ng batas is for the obligor to provide something of the same kind. Hindi nawawala yung obligation, hindi nagpe-perish yung indeterminate thing kasi kino-consider siya na genus, and genus never perishes. Palagi yung tatandaan. Kasi siya ay class. Article 1166, the obligation to give a determinate thing includes that of delivering all its accessions and accessories even though they may have not been mentioned. So, isa-isahin natin, ang tinutukoy sa article na ito is obligation to give a determinate thing. Sabi, it shall include delivering all its accessions and accessories, kahit pa hindi nabanggit sa agreement. Meaning of accessions and accessories. Accessions, the fruits of or additions to or improvements upon the principal thing. Example, house or trees on a land, rents of a building, air conditioner in a car, profits or dividends accruing from shares of stocks. On the other hand, pag sinabi naman nating accessories, things joined to or included with the principal thing for the latter's embellishment, better use or completion. Example, key of a house, frame of a picture, bracelet of a watch, machinery in a factory, bow of a violin. We have to take note that while accessions are not necessary to the principal thing, the accessory and the principal thing must go together, but both accessions and accessories can exist only in relation to the principal. Sabihin, pag walang principal, walang accessions at accessories. Palaging dapat merong principal. Right of creditor to accessions and accessories. The general rule is that all accessions and accessories are considered included in the obligation to deliver a determinate thing, although they may not have been mentioned. This rule is based on the principle of law that the accessory follows the principal. In order that they will be excluded, there must be a stipulation to that effect. Unless otherwise stipulated, an obligation to deliver the accessions or accessories of a thing does not include the latter. Example. So, example, the sale of a mobile phone. Yun yung ating principal thing. Necessarily includes with it the charger and the earphones. Yun yung accessions and accessories niya. Even though they may have not been mentioned. Halimbawa, nag-agree si A at B na A shall deliver to B his mobile phone. That necessarily includes the charger and the earphones, kahit pa hindi nabanggit. In order for them to be excluded, there must be a stipulation to that effect. Kung gusto mong huwag isama yung accessions or accessories, kailangan merong agreement or stipulation to that effect. On the other hand, the sale of the charger or the earphones alone does not necessarily include the delivery of the mobile phone. So again, the delivery or sale of the charger or earphones, which are considered accessions and accessories, does not necessarily include the delivery of the mobile phone, which is the principal thing. So, next, Article 1167, if a person obliged to do something fails to do it, the same shall be executed at his cost. So, anong tinatawag natin ditong obligation? Obligation to do something, so siya ay personal. Kanina, nag-concentrate tayo sa real, ngayon personal na. Fails to do it. The same shall be executed at his cost. Pwede daw gawin yung obligation at his cost. Cost ni obligor. The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. Meron tayong kino-contemplate ditong tatlong situation in performing an act or rendering a service. First, the debtor fails to perform an obligation to do. Second, debtor performs an obligation to do, but contrary to the terms thereof. Or, third, debtor performs an obligation to do, but in a poor manner. So, anong remedies ni creditor? In positive personal obligation, pag sinabi natin again, positive personal obligation, obligation to do. If the debtor fails to comply with this obligation to do, the creditor has the right first to have the obligation performed by himself or by another unless personal considerations are involved at the debtor's expense and to recover damages. Second remedy, in case the obligation is done in contravention of the terms of the same or is poorly done. Halimbawa daw, ginawa nga pero hindi sumunod dun sa specifications or pangit yung pagkakagawa, walang quality, it may be ordered by the court that it be undone if it is still possible to undo what was done. Pwede siyang i-require, i-order ng court na i-undo yung familiar naman tayo sa term na undo. Undo if it is still possible to undo what was done. So, pagdating naman sa performance by a third person, we have to know that a personal obligation to do, like a real obligation to deliver a generic thing, can be performed by a third person. While the debtor can be compelled to make the delivery of a specific thing, a specific performance cannot be ordered in a personal obligation to do because this may amount to involuntary servitude, which as a rule is prohibited under our Constitution. So, clear tayo doon. Hindi mo pwedeng i-compel si debtor na gawin yung isang obligation to do kahit pa nag-agree kayo, because according to law, this may amount to involuntary servitude, which is prohibited under our Constitution. Kung ayaw niyang gawin, kahit nag-agree kayo na gagawin niya yung isang specific na obligation, isang specific service halimbawa, hindi mo siya pwedeng i-compel because that will amount to involuntary servitude. Where, however, the personal qualifications of the debtor are the determining motive for the obligation contracted. Halimbawa, to sing in a nightclub, the performance of the same by another would be impossible or would result to be so different that the obligation could not be considered performed. Hence, the only feasible remedy of the creditor is indemnification. Hindi pwede ang specific performance kundi indemnification for damages lang. But where the obligation can still be performed at the expense of the debtor, notwithstanding his failure or refusal to do so, the court is not authorized to merely grant damages to the creditor. So, to illustrate, Hermes binds himself to assemble a vintage bicycle for Jinky. So, an obligation to do. This is a personal obligation. It was stipulated that the bicycle shall be painted all gold. If Hermes failed to assemble the bicycle, Jinky may ask Agot to assemble one at the expense of Hermes. So, yun, clear tayo doon considering na ito ay isang positive personal obligation. Kapag daw si Hermes, he failed to assemble the bicycle, Jinky may ask Agot to assemble one at the expense of Hermes. So, Hermes yung magbabayad ng cost. Next, suppose Hermes did assemble the bicycle but he painted it all white. Diba ang agreement kanina is gold. All gold. In this situation, Jinky may ask to have it done according to the specification. If Hermes refuses, the obligation may be performed by Agot at the expense of Hermes again. And third, if Hermes did assemble the bicycle and painted it with gold, but it was poorly done, Jinky may ask Hermes that it be undone, papatanggal, aalisin, or in case of Hermes' refusal, she may ask Agot to paint it at the expense of Hermes. In no case, however, can Hermes be compelled against his will to comply with his obligation should he refuse to do so. Hindi daw natin pwedeng pilitin si Hermes na magpintura kung ayaw niya. Again, because that will be tantamount to involuntary servitude. Next scenario, if Regine binds herself to sing the national anthem in the morning show of ABS and she fails to comply with her obligation, the performance of the same by another, like Moira, would be impossible or would result to be so different that the obligation could not be considered performed. Here, the personal qualification of Regine is the determining motive for the contract. Personal qualification of Regine. So, in this case, the only practical remedy of ABS is indemnification. Damages lang. Hindi pwede ang specific performance. So, yun, Article 1168. When the obligation consists in not doing, so negative personal obligation ito, and the obligor does what has been forbidden him, it shall also be undone at his expense. Remedies of creditor in negative personal obligation. In an obligation not to do, the duty of obligor is to abstain from an act. Ang duty daw ni obligor is wag gawin yung act. Here, there is no specific performance. The very obligation is fulfilled in not doing what is forbidden. Hence, in this kind of obligation, the debtor cannot be guilty of delay. As a rule, the remedy of the obligee or creditor is the undoing of the forbidden thing plus damages. Yun ang remedy is the general rule. However, if it is not possible to undo, hindi na daw pwedeng alisin, hindi na pwedeng i-undo what was done, either physically or legally, or because of the rights acquired by third persons who acted in good faith, or for some other reason, his remedy is an action for damages caused by the debtor's violation of his obligation. Remedy na lang is damages. Action for damages caused by the debtor's violation of his obligation. Example, S sold a land to B. It was stipulated, ibig sabihin it was agreed upon that S would not construct a fence on a certain portion of his land adjoining that sold to B. Should S construct a fence in violation of the agreement, B can have the fence removed at the expense of S plus payment of damages. So, ayun. Proceed tayo sa Article 1169. It provides that those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary. Hindi daw kailangan ang demand in order that delay may exist sa sumusunod na mga circumstances. First, when the obligation or the law expressly so declares. So, may dalawa tayo yung tinutukoy. One is obligation, second is law. Expressly so declares, or second, when from the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract. Or third, when demand would be useless as when the obligor has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. So what is the meaning of delay? The word delay as used in law is not to be understood according to its meaning in common parlance. A distinction therefore should be made between ordinary delay and legal delay, or yung tinatawag natin na default or mora in the performance of an obligation. So, to distinguish ordinary delay is merely the failure to perform an obligation on time. Legal delay naman, or on the other hand, or default or mora, is the failure to perform an obligation on time. Anong pinakaiba? Which failure constitutes a breach of the obligation? Ito yung, dito lang papasok yung breach of obligation. Pag ang pinag-uusapan na natin is legal delay. Kung ordinary delay, no breach of obligation. Kinds of delay or default or mora. Ito yung legal delays. Mora solvendi, mora accipiendi, and compensation mori. Mora solvendi, it refers to the delay on the part of the debtor to fulfill his obligation by reason of a cause imputable to him. Second, mora accipiendi, the delay on the part of the creditor without justifiable reason to accept the performance of the obligation. And third, compensation mori, the delay of the obligors in reciprocal obligations like sale. The delay of the obligor cancels the delay of the obligee and vice versa. As a result, there is no actionable default on the part of both parties. Again, we have to emphasize that there is no delay in negative personal obligation. Because in an obligation not to do, non-fulfillment may take place, but delay is impossible for the debtor fulfills by not doing what has been forbidden him. So, what are the requisites of delay or default by the debtor? There are three conditions that must be present before mora solvendi or delay on the part of the debtor can exist or its effects arise. First, failure of the debtor to perform his positive obligation on the date agreed upon. Second, demand, not mere reminder or notice made by the creditor upon the debtor to fulfill, perform, or comply with his obligation, which demand may be either judicial or when a complaint is filed in court, or extrajudicial when made outside of court, orally or in writing. And third, failure of the debtor to comply with such demand. Take note that the above presupposes that the obligation is already due and demandable, and liquidated. There is no delay if the obligation is not yet due or demandable. The creditor has the burden of proving that demand has been made. It is incumbent upon the debtor to prove that delay was not caused by his fault to relieve himself from liability. Example, S obliged himself to deliver to B a specific refrigerator on December 10. If S does not deliver the refrigerator on December 10, he is only in ordinary delay. Ordinary delay lang daw siya pag hindi siya nakapag-deliver noong December 10. In the absence of any demand from B. Although a period has been fixed for the fulfillment of the obligation, the law presumes that B is giving an extension to S within which to deliver the refrigerator. Hence, there is no breach of the obligation and S is not liable for damages. Again, kasi what was involved was only ordinary delay. However, if a demand is made upon S by B on December 15 and S fails to deliver the refrigerator, S is considered in default only from that date. Ang tinutukoy na date dito is December 15. Yun yung time when the demand was made. So, what are the effects of delay? Pagdating sa mora solvendi, the following are the effects. First, the debtor is guilty of breach of the obligation. Second, he is liable for interest in case of obligations to pay money or damages in other obligations. In the absence of extrajudicial demand, the interest shall commence from the filing of the complaint. And he is liable even for a fortuitous event. So, general rule, pag fortuitous event, na-absuelto yung party liable, pero in this case, he is liable even for a fortuitous event when the obligation is to deliver a determinate thing. However, if the debtor can prove that the loss would have resulted just the same if he had not been in default, the court may equitably mitigate the damages. In an obligation to deliver a generic thing, the debtor is not relieved from liability for loss due to a fortuitous event. Again, na-discuss na natin yung kanina. Hindi na relieve sa liability if ang bagay na nawala ay isang generic thing. He can still be compelled to deliver a thing of the same kind or be held liable for damages. More accipiandi, the effects are as follows. The creditor is guilty of breach of obligation. He is liable for damages suffered, if any, by the debtor. He bears the risk of loss at the thing due, and where the obligation is to pay money, the debtor is not liable for interest, and the debtor may release him from the obligation by the consignation of the thing or sum due. Third, compensation morae, the delay of the obligor. Obligor cancels out the effects of the delay of the obligee and vice versa. Parehas daw silang delay. The net result is that there is no actionable default on the part of both parties, such that as if neither one is guilty of delay. If the delay of one party is followed by that of the other, the liability of the first infractor shall be equitably tempered or balanced by the courts. If it cannot be determined which of the parties is guilty of delay, the contract shall be deemed extinguished and it shall bear his own damages. So, general rule again, no demand, no delay. Pag walang demand, be it judicial or extrajudicial, you cannot hold a debtor in legal delay. So, meron tayong ilang exceptions sa general rule. And these are the following. First, when the obligation so provides. Second, when the law so provides. Third, when time is of the essence. Fourth, when demand would be useless. Fifth, when there is performance by a party in reciprocal obligations. So, we discuss first, number 1, when the obligation so provides. The obligation must expressly so declare that demand is not necessary or must use words to that effect. So, clear tayo, must expressly so declare. Halimbawa ng expressions, without the need of any demand, the debtor will be in default, or I will be liable for damages. The mere fixing of the period is not enough. Remember that, mere fixing of the period is not enough. Kahit pa may nakaset na period, kailangan pa rin may demand. Unless, meron nga nitong expressly declared na hindi na kailangan. The arrival of the period merely makes the obligation demandable. Before its arrival, the creditor cannot demand performance. Example, D promised to pay C the sum of 20,000 on or before November 30 without the need of any demand. Therefore, if D fails to pay on November 30, he is automatically in default. Bakit? Because of these words, of this phrase, without the need of any demand. In this case, the participant to dispense with the demand. So, D is already guilty of legal delay or default. Second example, the contract of loan between D and C provides that failure of D to pay any installment therein stipulated would mature the entire obligation. So, ito yung inaabangan natin. Would mature the entire obligation. It does not state that in such an event, D shall thereafter be in default. Demand is still necessary to hold D in default upon failure to pay any such installments. He is not liable for interest for default for the whole debt except from the time that judicial or extrajudicial demand for payment is made upon him. So, dito, hindi sapat yung phrase na would mature the entire obligation. Kasi, given naman na kapag dumating yung maturity date, halimbawa nung loan, na talagang magmamature yung entire obligation and there was no express provision that demand is no longer necessary. Hence, if there was no demand made on such maturity date, then there is yet no delay. Second, when the law so provides, yung kanina obligation, this time when the law so provides. Same lang din sila halos ng concept. So, under the law, taxes should be paid. Example na ito, under the law, taxes should be paid on or before a specific date. Otherwise, penalties and surcharges are imposed without the need of demand for payment by the government. So, ayan yun. The law expressly so provides that there is no need for demand to hold the person in delay. Second example, the partner is liable for the fruits of the thing he may have promised to contribute to the partnership from the time they should have been delivered without the need of any demand. So, nandiyan na naman yung phrase na yan. So, kahit walang demand, automatic, the partner can be held liable for delay. Third, when time is of the essence. When the time of delivery is not fixed or stated in general and indefinite terms, time is not of the essence of the contract. In such cases, the delivery must be made within a reasonable time in the absence of anything to show that an immediate delivery was intended. Example, the delivery of balloons on a particular date when a children's party will be held. The making of a wedding dress where the wedding is scheduled at a certain time. Payment of money at a particular time so that the creditor could pay off certain debts due on the same date, and the delivery of a car to be used in a trip at a particular time, etc. Marami pa tong halimbawa, basta titingnan lang natin na yung naging consideration kung bakit yung parties nag-enter sa isang agreement or obligation is the time is of the essence sa kanilang agreement. In all these cases, the debtor or obligor is fully aware that the performance of the obligation after the designated time would no longer benefit the creditor. Kahit kahit i-perform mo after nung agreed upon time, it would no longer benefit the creditor or obligee. Fourth, when demand would be useless. How does this happen? Halimbawa, S obliged himself to deliver a specific horse to B on December 5. Through S negligence or deliberate act or by reason of fortuitous event for which S expressly bound himself responsible, the horse died on December 2. So, i-deliver siya ng December 5, namatay yung horse ng December 2. Under this situation, any demand for the delivery of the horse on December 5 would be useless, as S has made it impossible for him to perform his obligation. Kasi nga, namatay na yung horse on December 2 pa lang. Demand is also unnecessary where it is apparent that it will be unavailing, as where there has been a prior absolute refusal by S or S has manifested an intention not to comply with his obligation. And lastly, when there is performance by a party in reciprocal obligations. In case of reciprocal obligations, the performance of one is conditioned upon the simultaneous fulfillment on the part of the other. In yung reciprocal obligations. So, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. This is compensatio morae. From the moment a party in reciprocal obligations fulfills or is ready to fulfill his obligation, delay by the other begins. Doon pa lang daw nag-start ang delay. From the moment a party in reciprocal obligations fulfills or is ready to fulfill his obligation, delay by the other begins. Third, where the parties fix a period for the performance of their reciprocal obligations, neither party can demand performance nor incur in delay before the expiration of the period. The parties may provide different dates for performance of their respective obligations. So we're now with Article 1170. It states that those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. Babayad ng danyos. So, what are the grounds for liability? Article 1170 gives the 4 grounds for liability which may entitle the injured party to damages for all kinds of obligations regardless of their source. Mentioned in Article 1157, it contemplates that the obligation was eventually performed but the obliger is guilty of breach thereof. Here, the breach of the obligation is voluntary. In 1174, it is involuntary. First is fraud or deceit or dolo. As used in Article 1170, it is the deliberate or intentional evasion of the normal fulfillment of an obligation. Bad faith and fraud are allegations of a fact that demand clear and convincing proof. It is good faith, not bad faith, which is presumed. As a ground for damages, it implies some kind of malice or dishonesty, and it cannot cover cases of mistake and errors of judgment made in good faith. It is synonymous to bad faith in that it involves a design to mislead or deceive another. Article 1170 refers to incidental fraud or dolo incidente committed in the performance of an obligation already existing because of contract. It is to be differentiated from causal fraud or fraud employed in the execution of a contract under Article 1338, which vitiates consent and makes the contract voidable. Example, Bigasan obliged himself to deliver to Mayora 20 cavans of dinorado rice. However, Bigasan delivered 20 cavans of NFA rice knowing that it is of cheaper price. Bigasan is guilty of incidental fraud, and the remedy of Mayora is to claim damages to Bigasan. If Mayora bought the 20 cavans of rice on the false representation of Bigasan that the rice is dinorado, the latter knowing it to be an NFA rice, the fraud committed by Bigasan is causal fraud. Had Mayora known that the rice is NFA, she would not have purchased the same to Bigasan. Without the fraud, we would not have given her answer to the contract. Mayora has the right to have the contract annulled or set it aside on the ground of causal fraud. In the first situation, the remedy of B is not annulment of the contract of sale which is affected by the incidental fraud but to claim damages. If the fraud employed by us to get B's consent was not the principal inducement that led B to enter into the contract, the fraud is also incidental under Article 1344, and it will likewise give rise only to an action for damages. So second, negligence or fault or culpa. It is any voluntary act or omission, there being no malice, which prevents the normal fulfillment of an obligation. Third, delay or mora. This has already been discussed. Contravention of the terms of the obligation. This is the violation of the terms and conditions stipulated in the obligation. The contravention must not be due to a fortuitous event or force majeure. So, fraud and negligence distinguished. Fraud, there is deliberate intention to cause damage or injury. Sa negligence, there is no such intention. With regards to fraud, in waiving for future fraud, waiver of the liability for future fraud is void. Pagdating naman sa negligence, such waiver may in a certain sense be allowed in negligence. Third, proof required must be clearly proved. Mere preponderance of evidence is not sufficient. Negligence is presumed from the breach of a contractual obligation. And lastly, extent of liability. Liability for fraud cannot be mitigated by the courts. Liability for negligence may be reduced according to the circumstances. They are similar in that both are voluntary. That is, they are committed with volition, but in fraud, a party by his voluntary execution of a wrongful act or a willful omission knows and intends the effects which naturally and necessarily arise from such act or omission, which deliberate intent is lacking in negligence. So, when is negligence equivalent to fraud? Where the negligence shows bad faith, or is so gross that it amounts to malice or wanton attitude on the part of the defendant, the rules on fraud shall apply. In such case, no more distinction exists between the two, at least as to effects. Gross negligence is negligence characterized by want or absence of or failure to exercise even slight care or diligence, or the entire absence of care, acting or omitting to act on a situation where there is a duty to act, not inadvertently but willfully and intentionally. So, ayun, that ends our part 1 of module 3. For questions and clarifications, we shall discuss them next meeting. So, that would be all for today. Please reserve all your questions sa ating next meeting. Thank you!